Greetings. My name is Lieutenant Commander Terrence Thornburgh, and with me is Lieutenant Catherine Ward. We are both Special Victims Counsel in the United States Coast Guard, and we're assigned to an operating location out of Seattle. We provide legal representation to victims of crimes. These crimes primarily are sexual or domestic violence related, and to victims in the U.S. Coast Guard. And our primary area of responsibility include the Pacific Northwest, that's Washington and Oregon, and the state of Alaska. We're here to talk to you about transfers in the United States Coast Guard. The views that we express in this recording are our personal views and not the views of the service, our office, or the SVC program. What objectives will we be covering today? One, we're going to discuss these various kinds of transfers, 3 in total, how you can apply for them, what are the eligibility criteria, and then we'll also talk about some resources and partnerships that you may be able to leverage when confronted with complex scenarios. The 3 kinds of transfers include expedited transfers, safety relocations, and early return of dependents. I'll go ahead and turn it over to Lieutenant Catherine Ward, who will discuss the first. I'll discuss the second, and she'll close us out with the third here. So, floor is yours, Lieutenant Ward.
We'll first talk about expedited transfers, and contained in this slide is the authority. So it's actually codified in Title 10, and then the implementing policy that the Coast Guard utilizes to execute these legal authorities and program. In addition to the policy, we also have a procedure guide, but that's not necessarily available publicly, but it's something if you were to work with us as POCs or had particular questions, we would be able to talk through more nuanced examples. But essentially, the substance in the process guide is pretty much contained in this slide, and we'll go through that on a later slide. So an expedited transfer is kind of as it sounds. It's an opportunity for certain eligible persons in the Coast Guard that are victims of certain qualifying offenses to leave the unit at which the offense took place, either temporarily or permanently. And we'll talk about some of the reasons why a member would want to execute a transfer. But again, this is something that's actually codified in law, and it's taken very seriously. And it's offered for victims to be able to separate from the subject and be able to, especially if it's a small unit, kind of start fresh. As far as eligibility, that's something to kind of really keep in mind. We do particularly deal with the types of victims that would normally be eligible, but there are some reasons why potentially an otherwise qualifying victim would no longer be eligible. And some of those are contained here. So first is that the member has to make an unrestricted report, a credible unrestricted report of a qualifying offense that we discussed in the first slide, qualifying offenses being sexual assault, rape, and it's important to note here that the report has to be unrestricted. So we have the option restricted and unrestricted reports in the Coast Guard, where a restricted report doesn't necessitate an investigation, but there are a lot of policies and things that wouldn't apply to that person, and this being one of them. Because, it would naturally follow that if it's restricted, the command wouldn't know, they wouldn't be able to execute this request. So a member has to officially decide that it's unrestricted to utilize this option. The member is not the only person that's eligible for this. They also expanded the policy to afford a request that's on behalf of the service members, dependent victims as well. And this would be, for the same kind of purposes that a victim would otherwise want to transfer, especially if it's a unit that is OCONUS, which is a unit, in Alaska or Hawaii that's separate from the continental US, or, a small unit. In addition to those requirements, the expedited transfer request should be made in order to take advantage of the timelines that are afforded by law of 72-hour response period, which we'll talk about in a later slide. But the member should make that request for an expedited transfer at the unit in which the qualifying offense occurred to be able to fall under those timelines and policies. They could otherwise make that request, but an appeal option, the 72-hour review window, wouldn't apply. And the last thing would be that the member cannot execute more than one expedited transfer request for the same qualifying offense. So if a transfer is executed, they're no longer able to request one. And sometimes we have seen, or at least I've seen, a member that has sought an expedited transfer request and never executed it, but it was still under our personnel branch, considered to be executed. They were no longer eligible to make an expedited transfer request on that offense. We'll talk about a little bit distinguishing factors between who the victim is in the scenario, because depending on the victim, the classification, two programs might apply. So the first being the family advocacy program. That would be involved in a scenario where the offender is, married, a spouse to the victim, or living for greater than 1 day with the victim, or the victim is a child under the age of 18. The program is designed with the intention of reuniting families and solving issues of a family-related concerns. So it naturally kind of pulls those cases in that direction. And the policies for expedited transfers that are afforded under SAPR, which is denoted here above, is not actually applicable to the FAP cases. So as far as the SAPR program, and you can see that acronym spelled out there, that pertains to all other qualifying offenses and victims of sexual related and domestic violence nature. And the SARC would be the responding person in those scenarios, and they would be assisting and pretty involved in any expedited transfer request on behalf of the victim. The process that I talked about in the guide, we'll kind of go through a little bit here to understand what's afforded in policy and why once a request is made, it moves along pretty quickly, and that is intended to be the case because previously, a request might be made and there is concern of safety, there's concern to leave that unit immediately, so there is an impetus for response and action on behalf of the involved party. So once a victim decides that they want to make a request for an expedited transfer, it's a request that is made to the command, and that can be done informally. I've seen it just from a SARC by a one-line email, and a SARC is the sexual response coordinator that I talked about on the previous slide, or it can be something a little bit more formal that comes in a memo. It's essentially the importance of making this request to command is that it triggers a 72-hour period that the command has to reply to the request. So that's contained in the next block here, that the command gets this request and they have to endorse or negatively endorse the request from the service member. And I usually, as an SVC, give the command kind of a courtesy heads up before making this official request, so they are aware of it coming, as well as trying to figure out, if they've never done the process before, how to figure out the memo and the proper people to confer with. So once the command makes an endorsement, they formalize the memo, and it's a template that's included in our policy manual, and it essentially endorses the request, says that these are the locations the member wants to go to. It's not going to be an imposition on the investigation, and a lot of other considerations that go into it. Once they make a decision, it goes to our personnel service branch, PSC, and they review the request, and they look at what available units there are, and taking into account, the victim's rank, rate. You can imagine the higher up in our service, maybe the more difficult it would be to place a person in a particular place they'd like to be. But the lower ranks, if it's like a seaman or a lower enlisted rank, there's potentially many more options that could kind of satisfy all their desires. We can talk about some of those considerations as far as location, but PSC is going to be the point in this process that really evaluates what's feasible, what's open. And I have seen, great interaction with the branch to kind of figure out the best case for the service and the member. So once you hear back, either denying or approving from PSC, if approving, the member can execute it as if any other move, and they can proceed with their administrative branch and go to the next unit. There's going to be some pass down that we can talk about on a following slide if there's still investigation that's active in the case. Otherwise, if the investigation is over, it's essentially the member starting over at a new unit, and disassociating from a really traumatic event and potentially, ostracism and difficult things that they've been experiencing at the unit. In the unfortunate circumstance that it's denied, they also have an opportunity to appeal. And that's why I noted on the slide previous to this, it's important for the member to make that request at the unit of the qualifying offense in order to take advantage of this afforded policy, that if they do deny it, there's a window for appeal. There are some guidelines too to keep in mind for expedited transfers. This is not a right to transfer on behalf of the member. And I think a couple of things I already discussed make that clear, because it can be denied. So there's no right to transfer, but there's a right codified in law and our policy to make that request. There's also, like I said before, the actual request from the service member is not a formalized necessarily request. It could be very simple and just an email that serves as this notification, triggering notification, but there is a memo that the command will use. As far as where to transfer the service member, some of the considerations that are included in our policy include victim safety, which is embedded in our Article 6B rights for the service member to be protected from the accused. And this is, a big concern if it's a small unit, if it's an underway unit, where there's frequent interaction. So in addition to the opportunity for applying for no contact orders or protective orders, this could also be a really great avenue to separate the victim and the accused member. In addition, medically and mental health services might not be available to a member that's at a unit that's far away or just doesn't have much infrastructure. So that might be another reason to transfer. And lastly, victim recovery includes a lot of things, so being close to family, friends, where they grew up is really helpful for a client to move on from a really traumatic event and have the support network and the ability to kind of have, familiar faces there with them when they're going through this. So all of those things are considered, and oftentimes the location and proximity of the family comes up as a very important factor that PSC considers the personnel service branch when they decide exactly where to send the member, knowing that there are limitations as far as what billets are open for that rank and rate. And there also are some challenges too if it's off cycle, because typically in the military, we rotate during the summer months. So if a request is made in the middle of winter in February, it might be a little bit more challenging to get into those billets that otherwise would be open. Talking about billets too, it's not only just a location. We have hubs in the Coast Guard of larger units. San Francisco, Charleston is increasingly becoming one. And those areas can be requested, but also particular types of units. So we often see clients request units that are on land for continuity of care, to not be re-traumatized from a unit that's underway potentially where the incident occurred. So frequently it's land-based, particular types of billets can be requested, but it's always a good position for the service member to provide options and not be stuck on a certain location being the only place that they would want to go, because there are a lot of considerations that the Coast Guard takes into account. I also want to clarify too, the command receives these preferences. So they don't write the endorsement and say, recommend an area that's, separate from the victim, the service member's preferences. Those are offered through that initial request. And then the command will include that in their memorandum. It's not something that they would do independently. And I think that's sometimes a concern that I get from clients, that once they make a request, it's kind of a process that's out of their hands, but that's not necessarily true. In addition to the request, the CIT, which is essentially just a group of stakeholders in this process that would potentially be concerned if an expedited transfer request were executed. And that includes the SARC, which is maybe the first person that ever gets to report. And they are well aware of the needs medically and mental health wise for the service member. CJIS, if there's an active investigation and they think there's going to be some kind of imposition on a move, especially if it's far away from the incident, they might have some concern. And then the command as well. They'll all come together and kind of come to a concurrence. But on that note, the command, the endorsement is necessary to ensure there's like a thorough, thoughtful discussion about any kind of consequences of a transfer. But if the command doesn't endorse the request, it's not necessarily fatal. And PSC is the final approval. And we as SBCs do have room to advocate on behalf of our clients and kind of provide maybe a little bit of context they wouldn't have otherwise had from the memorandum that the command submitted. And lastly, just to clarify, this request is like any other transfer in the Coast Guard. It's at government expense. So the member is going to execute it as any other transfer, working with their administrative staff. They'll pay for their household goods moved to be picked up and shipped, and all the entitlements would attach. So any concerns about financially being able to afford this does not exist for expedited transfers. On the next slide, we will talk about safety relocation, which I'll pass it back off to Lieutenant Commander Thornburgh.
Hi, thank you. Thank you for the warm handoff. So safety relocations is a tool and policy that's, at least from my experience, not often known or talked about, but it is something that's buried within the Coast Guard's policy on transitional compensation for abuse dependents. And so one way you could reference it if you're working, say, on a particular case where this looks like a helpful mechanism to provide safety to your clients or the dependents is to reference that policy, to simply say, hey, Coast Guard POC, and this is typically going to be your family advocacy specialist, because these cases that involve dependent abuse offenses are going to arise within the FAP context, FAP being the Family Advocacy Program. And so in slide 8, Lieutenant Ward had talked about the difference between a case that arises under the Family Advocacy Program versus, say, the SAPR program, and how different POCs will be working with the victim depending on which program is involved. In the case of safety relocations, because you're talking about a domestic abuse context, family advocacy will be involved. And so the Coast Guard point of contact will be interfacing with the client or the dependent. In that case is going to be the family advocacy specialist. And so referencing that policy to them and saying, hey, there is a safety concern, and there is this mechanism within a broader policy to relocate the victims for their safety is, I think, a good first place to start. If there is a question about whether, a question about options that would work to provide safety by relocating the abused dependent. So what is a safety relocation? So it is what the term suggests. It is a relocation of the victims of abuse. Generally speaking, these are going to be the dependent spouse of the service member and or dependent children, relocating them away from the perpetrator service member for their safety. So it's a requirement that the service member be the perpetrator, and it's a requirement that dependents be the victims, right? And because it's arising in the family advocacy context, FAP will be involved. And if the request for that relocation is successful, then those dependents will move at government expense. There will be cases where the dependents cannot afford to move on their own dime, and so having this benefit is going to be important for those cases. So how do you apply for this? A couple of things have to be checked, right? The first one I think we've discussed, it's that the service member has committed a dependent abuse offense against dependents. In a later slide, we'll define exactly what we mean by dependent abuse offense, but it is a broad term that encompasses a lot of conduct, both physical and non-physical. So that's point one. And point two is the safety plan, right? So family advocacy must have come up with a safety plan and counseled the dependents on it. And the safety of those dependents must be deemed to be at risk, right? If they continue to remain within proximity of the service member perpetrator. And in light of those factors, it is advisable that they be relocated. So those are the prongs you have to hit in policy to be eligible for this, this safety relocation. So what is a dependent abuse offense? So it takes the same definition that applies for transitional compensation and uses it for this transfer, right? And so the service member who is the perpetrator must have been on active duty more than 30 days. And again, the conduct must be directed towards the dependents, the spouse or the children. And the conduct must be deemed criminal under some applicable like statutory context. So typically we think UCMJ, because that's what applies to service members, Uniform Code of Military Justice. It could be federal law. So US Code, US Criminal Code, or it could be under state law. And then the conduct could be both either or, physical or non-physical, right? And those are broken out and defined on this slide here. So again, it is broad and isn't limited just to, physical type abuse. Okay, and then the final thing I'll say about safety relocations is that oftentimes in cases within which questions arise about relocating dependents, there may also be some consideration as to what that would mean if there's a pending divorce or if there's a custody battle. Sometimes those will overlap and run concurrently. And so it's one of those considerations to take into mind because it may impact the advisability of pursuing this and moving the dependents, out of state or some other place. So in our case, what we may do is refer or loop in a legal assistance attorney who practices within the family law area to provide some guidance on that piece. So that's the only other thing I'll offer on this safety relocation. And then I believe on the next slide, we'll be discussing early return of dependents.
And for our last option of transfers, I'm going to talk about the early return of dependents. And included here are the authorities. So the joint travel regulations are also applicable to this program, as well as our policy that talks a little bit further about how we implement it. And similar to the expedited transfer request, the personnel service branch does handle these as well. And they also fall under the FAP program. The early return of dependents is a program that affords the opportunity for a qualifying dependent victim to return back to CONUS, so the continental US, from a unit ahead of the date that the service member would have otherwise transferred. And there would be several scenarios that would necessitate potentially a request for this or a desire on behalf of the dependent member to depart from a no-CONUS location and depart separately of the service member that's serving there. And to clarify too, like the expedited transfer, this is something that can be afforded to the member, the dependent member, spouse, at government expense. So the move, the entitlements, and even shipment of a car on some occasions, especially if it's from, Alaska and some of our more isolated units, are authorized for a dependent member. As far as eligibility for early return of dependents, it applies to qualified dependents of service members, and these service members have to be stationed at OCONUS units. So for the Coast Guard particularly, that would mean Alaska and Hawaii. And it would allow the dependent member to return back to the continental United States. And the scenarios listed under the joint travel regulations, there's 8 of them. And the context that would most likely apply to the scenarios that we are dealing with would be when the service member is actually the subject of the disciplinary action. So for instance, if we're representing the dependent client who was the victim of the spouse's abuse, that would be a reason to request an early return of the dependent that's the victim in the scenario. It's a request that is reviewed by the Coast Guard, and it has to be deemed in the government's best interest, and that the current location of the dependent is not able to address, based on resources, the issue at hand. So it's essentially just a review that finds it necessary to transfer the dependent back to the United States. The process for requesting an early return of dependents requires the submission of the active duty service member. So as you can imagine, in scenarios where potentially the service member is the alleged perpetrator, it's going to require a lot more command involvement to ensure the proper paperwork is submitted to get the process forwarded to the personnel service branch. So this is a process, just to clarify, that is not done on behalf of the victim. It's done on behalf of the service member that might be the perpetrator in that scenario. The chain of command of the active duty service member will review and endorse, and then continue it along the process for review with administrative funding, a TONO number, which is essentially an accounting string, and then it goes to our personnel service branch as the final reviewer to release the funding and to execute the request. The differences between the services, we have a lot of similar policies in place with the Coast Guard. I think one of the differences we may see is based on the smaller size in our service. So I can't really speak for the other services as far as when they do engage with the personnel service branch for particular locations or desires on behalf of the client. But I know for us particularly, I have seen a great relationship exists to really hear what the victim is desiring, as well as kind of, have policy that might not be black and white to afford something they request, but be able to work with us. So all of the applicable policies as far as expedited transfers and the under Title 10, those still apply to us. We just potentially might have a different process guide that goes through as far as the stakeholders. But Terrence, is there anything else you can offer as far as differences that you've seen?
No, I don't think so. I think you're spot on in terms of differences. They're going to be in terms of the implementation of the policy. And so I believe in this case, with regard to those three, we provided the policies that are on point that will be instructive and then would guide how the client or the member of the dependent can go about seeking that process.
For any additional information about what we talked about today, this is a great inbox that you can send a request to. I do want to clarify, this is the same email address that actual requests for SVC go to. So it's going to go to all SVCs. We will see the request, and then it's going to be addressed accordingly based on the priority level and what kind of information they're seeking. So we tried to include all the policy manuals within the slideshow, but there are particularities with every case, and no expedited transfer or ERD that I have executed has been the same. So if there's anything in particular you'd want to speak to us about, we, like every other military member, eventually transfer, but this is an inbox that you would always be connected to the currently serving SVCs in the program.